let's zoom straight to the presentation. We're talking estate and gift planning. Time to protect you and your family. So I believe the natural person, Doc just left here, the academics will want to begin with the definitions. What is estate planning or estate and gift planning? Gift will be the two. I'll use the two as one. So I'll be talking more of estate planning, but we will deal with gifts when we get there. So first, let's understand estate. Estate refers to all that you own as your personal property. Everything you own as your personal property. There are some things you may own them wholly as the sole owner, and there are others you own in association with others as a part owner. Now, those the ones that you own proportionally and the ones that you own wholly, when you put them together, forms your estate. So as we sit here, every one of us here has an estate. You own something. At least you own a mobile phone. So you own something. You have an estate. The sizes of the estate differ. But every one of us owns something. Every one of us has some estate. I believe we appreciate that point. Yes. So that is estate. Now, if you look at Article 18.1 of our Constitution, it says that every person has the right to own property, either alone or in association with others. So, you see, acquiring property is so important to the state, such that the right to it is guaranteed in the Constitution. So you have a right to acquire property, and as soon as you acquire a property, it comes to add to your estate. And that is how come estate planning or discussions about your estate is important, because one way or the other, we all have property. Now, let's continue. So, we see the estate. Now, as I mentioned, acquiring property, disposing of property are some critical part of the law and some of the aspects of justice delivery in Ghana. So the state has laws governing how our estates are managed. And it begins right from the Constitution. I just mentioned property acquisition. Article 22.1 will also tell you that a spouse has entitlement to the estate of the spouse. Whether you provide for your spouse or not, the Constitution says that once that is your spouse, upon your death, the spouse has some share in the estate. So those are constitutional provisions. Then you come to statute law, that is the laws passed by Parliament, which also contain several provisions on how we handle our estate, beginning with the Administration of Estate Law, Act 63. Then you come to the Wills Act. You have Pnbc Law 111. They are all dealing with how we manage our property. Some specific properties like land have their own laws. So they are also there. Now, the law has a default plan for you concerning your estate. So you look at the Administration of Estate Act, Section 1.1 says that the movable and immovable property of a deceased person shall devolve on his personal representative with effect from his death. So the law says that the moment you die, your personal representative inherits your property. That's all. So there's a legal default position for you. we are familiar with our phones. When you buy a phone, there are default settings. So you can decide to change them to what suits you. You know, when there are some items, when you are buying, they will tell you, we have the factory settings or the default, and then you can customize to what you like. You get it? So the law has a default position for your estate. The state has planned for you. Parliament has planned for you that, assuming, like Doc said, you fall within the class of people who fail to plan your estate. The state has a plan for you that will kick in. And that is what I just read. Now, estate planning, in estate planning, you are trying to avoid the default. You are trying to avoid what the law has set for you, because the question here is, who is your personal representative? Who is your personal representative? You see, so let's look at what the law says. In the same Administration of Estate Act, if you look at Section 1.2, I read Section 1.1, this is Section 1.2. It says that your personal representative, if the estate is passing on by way of custom, then it's your customary successor. That is your personal representative. So, and we know how custom operates. It differs from place to place. The custom of the GANs will be different from the ACANs and from the EWES and from the Nzimas or the Tagati, Dagbon. It differs. So the law says that if that particular part of your estate is passing on by way of custom, then it goes to your customary successor. You know, after your death, you don't have a say in who succeeds you. So you want to do that before your death. If not, you don't know who succeeds you. We read, when you read the Chronicles and the books of the First and Second Kings all the time, you hear that one king was good, another was bad. One did well in the sight of God, another did bad. So you don't know who will succeed you. You don't know who will come after you. So you don't want to leave that to the state, because the state has provided for you. You want to take that decision deliberately. You want to be sure who is coming after you, who is taking this property you have toiled to acquire. That is estate planning for you. So the second aspect is that in any other situation where it is not passing by custom, the Chief Justice is your personal representative. That is what the law says. It says that in any other case, in the Chief Justice. So the law has a successor for you. Whether you choose to plan, if you choose not to plan, then the law has a successor for you. Either your customary successor or the Chief Justice. You see, you want to avoid that. That is estate planning. You want to be deliberate. You don't want the Chief Justice to succeed you. He has so many things doing. He has no time for your little, estate after your death. So eventually, your estate will fall in hands that probably you may not want it so. So we go in talking estate planning. We have to all take it serious. Now, Pnbc Law 111, which we all hear every day, also has default positions for you. Pnbc Law 1 is specific. It begins to break the discussion into specifics, saying that if you fail to plan your estate, fail to make provisions whilst you are alive and you die, or our property is divided into two, movable and immovable. Movable property, immovable. First of all, Pnbc Law 111 says that when you die, all your movable property, every property that is movable, the meaning comes from the name, movable. The ones you cannot move, are land and houses. So every property movable, goes to your wife and children, if you have any. So all your movable property first goes to your wife and children. Then the law says that your immovable property, one house, also goes to your wife and children. Then if there are others left, the law now breaks it down into how it should be shared. So the law has a default position for you. Now, as I said, in estate planning, you want to be deliberate. You want to avoid the default position of the law. So how do we go about this? How do you plan your estate to avoid the default position? You may not, when you take the Pnbc Law 111, what I just read, one challenge, and which, there's a new bill entirely before Parliament to amend Pnbc Law 111. What if the person has more than one wife? The law says that you're at least one house. So somebody dies leaving 9 houses. The person has 3 wives. You get it? The law says that one of them goes to your spouse and children. So assuming that of these 3 wives gave him 16 children whilst he was alive, he has 9 houses. The law is only giving your 3 wives and all the 16 children just one house out of the 9. And then the 8, the law begins to break them into smaller pieces. You will see that is an unfair situation. That is an unfair situation. But that is the provision of the law. So if you want to avoid these things, this is where estate planning comes in. Don't leave it to the default position of the law. Be deliberate. Indicate specifically, whilst you are still alive and you still have the chance, determine who takes what. So that this person, like the scenario I described, can conveniently share the 9 houses among the 3 wives and children such that each of them will be comfortable after his death. Imagine 16 children and 3 wives sharing just one house. What will eventually happen is that they will sell it and share the money. They will sell it and share the money. I handled a case in which a woman left 2 houses for 2 children, and they could not share it. 2 houses, 2 children. They fought over it. It came to court. The court ordered a sale of the 2 houses, share the money. 2 houses, 2 children. So imagine 1 house, 3 wives, 16 children. That would be worse. So you don't want that to happen. If this woman, whilst alive, has shared the 2 houses for the children, there will be no problem. But because she left it to the default position of the law, what created the confusion was that all of them wanted a particular house. And that is what created the confusion. The other one, they didn't want it. So all of them, I want this house. I also want this house. That is what started the confusion. So we are looking, let's take this whole discussion of estate planning serious. Now, I guess by now you understand estate planning. You deliberately deciding whilst you are alive who should take certain portions of your estate. So I have a car, I have a mobile phone, I have a bank account, I have a house. I want A to take the house, B to take the car. You get me? That is estate planning. Being deliberate about who succeeds you in respect of your estate. That's estate planning. How do we do it? What we call estate planning tools. How has the law permitted us to appoint and decide on the estate? The first one is gifts. And so the gift planning also comes in now. Gifts. Whilst alive, you can give gifts of your estate to those you want to give to. So let's say you have 4 houses and you have 2 children. Whilst alive, you can decide to specifically, like the scenario I mentioned, 2 houses, 2 children. And after the woman's death, all the children, each of them says that I want this particular property because of the location. And it led to a confusion. Assuming whilst the woman was alive, she planned the estate by way of gift and says that I give this one to you and then I give the other one to you. That will have solved the problem. Now in doing gifts, we have what we call the customary way of gifting, and then we have the common law or the let's say the modern way of doing it. So customarily, when you are gifting, the law requires that there will be witnesses. There will be witnesses. And the beneficiary of the gift will do what is popularly called asida, or thanksgiving. So once you receive the gift, you must show appreciation. You must go back and show appreciation. Normally, if those of us that have experienced a customary gift, they will go with either a drink or money, or a smaller gift, let's say an animal, say a goat, which is common, or fowl, turkey, and go and thank the person. Now, the law also says that when you enjoy the gift, it is also a form of asida, thanksgiving. You understand? A gift has been given to you. When you enjoy it, you use it. The law says that that is also thanksgiving. Showing appreciation that the gift is important to you. So you've been given a gift of, say, a shirt, and then you fold it and put it in the bag. That is a sign, probably you don't like it. But when you put it on and you are wearing it, and the donor, the one who gifted you, sees you wearing the dress around, the person knows that at least I've done something. So the law says that when you enjoy the gift, it's a form of asida. Now, if the provision, the requirement for witnesses and asida are not present, the customary gift will fail. If you are not able to show that you did the thanksgiving. So those of us that are familiar, we know, normally they will take some elders as witnesses, especially when fathers and grandfathers gift farms and, real property to, their children or nephews, nieces, and grandchildren. They go back with some elders to go and say thank you, and then also to have some witnesses to witness what has happened. So the two must be there. Then if you want to do it by way of modern law or common law, then the requirement is that you should put it in writing. There should be a deed of a gift, and then it should be signed. The major signature requirement is the one giving the gift. The signature of the receiver is normally done, but it's not what the law looks for. The law looks for the one giving the gift. Now, there are certain things you should look out for. If at the time the person is giving the gift, the person, the donor or the one providing the gift is blind, cannot hear, it's a bit mentally challenged. You have to be careful. How do you convince the court that this is a proper gift? It could be that you did something and you told him, Nana, bank for number, almost a sign. You get it. Then the person signed, not knowing that is the death warrant. So there must be a jurat that says that this person is blind as at this time, but then Mr. ABCD helped him to execute this document. So please, in doing common law gifts, keep your eye on the condition present at the time you are doing the gift. So gifts are one. When you are doing estate planning by gift, you are still alive and you are still giving the properties. It doesn't sit well with us here in Ghana because of our culture. We think that my job, it doesn't sit well with us. But times are changing. Times are changing. So we cannot continue to hold on to that mentality. It doesn't mean you are dead. You are still alive. You get it? You are still alive. You are not dead. So let us look at it. You step out today, you may not return home. And you don't want a situation where, because your children are younger and cannot fight, one family member who can bully them around jumps in and takes everything. We do cases like that. One, macho or King Kong, not in terms of the body size, but some people are very aggressive. When you do gifts, it doesn't mean you are going to die soon. That is the problem we have. And it is also the problem why people don't want to do wills. It's also the problem. They feel that, when I do will, means I may die soon. I don't want to do it. Let me be there. And that by that kind of thinking, we are assuming that we will be sick and die slowly. So we can see us dying. And then we now do the will. Death doesn't come that way. We all know. It is not in all cases that we can tell that, look, I'm going. Some come suddenly through accidents, unforeseen situations, heart attacks. They don't tell you. It just happened. You are gone. You are gone. One of the traumatizing situations I had was I did a will for a certain man. He had 2 wives, and so he was keeping 2 sets of families. Now, there was an understanding amongst them. The first wife and her children have their house where they are. The second wife and her children, they also have their house. But his problem was his business. He was operating a shop at Kokompe. And it was his business that was his problem. He wanted a particular person to take over and run the business. So he didn't want to leave that one to, dissipation after his death. So he called me and we did the will. We were supposed to sign it on a Tuesday. That Tuesday, I think it rained. We couldn't go to the house. Wednesday morning, when I got to the house, they rushed him to Kolebu. He didn't come back. So we've done the will, printed it out, but not signed. I couldn't forgive myself. For several weeks, I was very disturbed. So what happens? 2 rival women and their children. And they were all grown-ups. There was no child among them. How am I going to face them to let them know that this is? For weeks, I was very traumatized and kept praying and looking for an answer how to handle the situation. Luckily, I showed it to my senior. He said, go and deposit it at the High Court. That is his will. We deposited it. The family knew, the wives knew he was working on a will. So they called me in. We went to the High Court. It was read to them. Said it's not signed, but that is what the man instructed. Luckily, they accepted it.
Is that you go to the land, you go to the person who is selling the land. You will give you what we call the side plan. When he gives you the side plan, you have to go to Lands Commission to see whether the person selling the land to you is the one who is supposed to sell to you. Because the land could be for the family. So in law, what we normally ask people to do, that when you get a side plan, you go and check. But you ask the person selling the land to give you what we call abstract of title. I'm talking about document. That's what I'm saying. You need that abstract of title. The abstract of title is a document that will talk about the seller and the buyer, the intention of the person who will come to sell the property. In law, we have something we call caveat emptor. That means the buyer must be aware. So you, the one going to buy the property, you have to be aware whether the person selling the property to you is the rightful owner. If it's not the rightful owner, that he has capacity to sell. That is why you need the abstract of title. And the abstract of title will tell you who is the seller is, who is the buyer is, where the property is, that is the schedule, it will tell you. Then within the abstract of title, we also have what you call root of title. So these are documents you need. The root of title will also talk about the history associated with the land for the past 30 years. So we say that for the last 30 years, what has happened on the land? Who has been owning the land? Who originally owns the land? And when the land was there, where did it come from? We are not doing academic ways. We are not going to talk about allodial, free wills, and those things. But in Accra, and in mostly Ghana, most of the properties that we have are leasehold. The article 266 or so says that if you want to give you a leasehold to a Ghanaian, it should be 99 years. But if you want to give to a non-Ghanaian, it should be 50 years. So if you're a non-Ghanaian and you buy a land in Ghana and they give you a leasehold of 99 years, this boy, they say this Ghanaian footballer who is in France, decides. He came to Ghana, he went to Nungwa, I think that's where he came from. They performed a function for him and gave him a big land, and they leased it for 99 years. He took his to lands registry, he saw a lawyer, and the lawyer told him that this document is void. You are not a Ghanaian, so they can't lease you for 99 years. At that stage, he was confused. So when you get your side plan, your abstract of title, and your root of title, then they prepare the indenture for you. When they prepare the indenture for you, it becomes yours. When it becomes yours, as an estate planner, you are holding on to it. But it's possible that after the property was given to you, you also want to sell to somebody. So at that stage, a lease has been given to you for 99 years. You also want to lease it for somebody for 50 years. So that after 50 years, it will come back to you. You do what you call sub-lease. So it is not all the lands that you buy that you become the absolute owner of it. You must always look at the indenture and look at the number of years the land has been granted to you. So if that begins to you for 99 years, and you think that for the next 50 years, you will not use the land and you want to give it to somebody, it becomes a sub-lease. After 50 years, it will come to you. It won't go to the chief who gave it to you. Then there's another way. Maybe it was given to you for 99 years, but you don't need it again. You have stayed on the land for 9 years. In order to give it to somebody again for the rest of the 90 years, that also becomes an assignment. So the document you now prepare for the person who is coming to buy the land is no more a sub-lease again, but it becomes an assignment. Because the next 90 years, you are assigning to somebody. So these are the documents you have to look for when you are looking for a land. Like my senior said, gifts. You want to give something to somebody before he goes. But before we go on, now one important document everybody must be prepared to go for is the Ghana card. Whether you like it or not, it's an important document you need to get. If you go to Belton, they have what you call health insurance. It's called national insurance. If you go to America, they call it green card. If you go to Canada, it's also green card. So Ghana card is also becoming a form of green card in Ghana. And I expect all of you to get one. Forget about your political colors. Please go for it. Because the previous government attempted to bring it. If this present government has brought it, it's important we all get it. Let's forget about everything we get. When we get it, it will help us in so many things. The banks are saying that that's the only means they will use for identification. So go for it. So, and it will surprise you to know that in future, when you are going to do any transaction and you don't have a Ghana card, the transaction cannot proceed. So I appeal to you, all of you, to get your Ghana card so that when you want to do it. Because if you just want to transfer a property to somebody, you may have to add your Ghana card before you can transfer it. For the gifts, the senior has already spoken about it. If another way of giving a gift to somebody is probably use his name to purchase the property. If your father wants to give you a land, instead of buying the land before transferring it, you can use your name to purchase the property and process it in your name. Automatically becomes yours. It's a form of gift. In customary law, they call it intervivals. Customary intervivals. That is where the property is given to you and go and say thank you. If you watch our forefathers, even in Akan Palace, when somebody dies, the property goes to the nephew. So what they were doing in their days is that he will use his nephews to build the first house. Then he will distribute the first house to the nephew. At the back of the house, he do what they call a kitchen for the wife. So that when they finish the main house and he gives it to the family, then he goes to build another house for the wife. Before he dies, he presents that house to the wife and the children before he dies. And they thank him. So when he dies, everybody knows that he donated that house behind the main house to the wife and children. And the main house is for his family. And that was the way they were doing their things. So if you have any property and you want to give it to somebody, please do it. Get your gift in and it will be done. Another property people can get is maybe if they want to buy a car. If you buy a car too, it's a form of property. Because when you buy it, you also need a receipt. Anytime you are purchasing something from anybody, make sure that you get a receipt. Because if even no document has prepared for you legally, and you have a receipt, at least equity will come to your aid to say that because you have a receipt, there's evidence that there was a transaction. And don't rush, excuse me to say, don't apologize, my wife is a Gando, but they will tell you that, mama, if you build it to the length level, nobody can destroy it. That law, that was I think it was Act 2. It was saying that if somebody puts a property on a land and it's at the lentil level, you can't destroy it. That law doesn't exist again. So if somebody tells you that build your house to the lentil level, nobody can destroy it, it's not true. Today it can be destroyed. They will destroy it and ground your louvers and everything, and they will take over their land. So don't think that when you get to lentil level, nobody can take it. When you want to buy a car too, you must also check whether the person selling the car has capacity to sell. You know, there are some people who don't have capacity to enter into contract. These are minors, mental people, and people who are bankrupt. People cannot pay their debts. I'm sure if bankruptcy is implemented in Ghana, I may also fall because I don't think I've finished paying all my debt. See, I haven't finished paying all your debt. That is it. But in Europe, in America, they are very particular about those who cannot pay their debt when it falls due. And there are some crooks in Europe, when they are not able to pay their debt, then they quickly transfer their monies to Africa. They come and acquire other properties. Then after that, they will transfer it back to Europe and they go and enjoy it. Sometimes they're able to investigate it and trace it. Another property you can get is through mortgage. Mortgages, if you want to have a house, you can go to any of these mortgage houses, like Ghana Home Loans, now it's First Ghana Bank, HFC, now it is what we call Republic Bank. When you go there, they will take you through process. The good thing about these mortgage loans is that the period is long. I acquired one at Ghana Home Loans, and I finished paying just last year. When I was paying, I was not even feeling it. I acquired one at Adesta, and I was building my own house at Amasama. But later, when I finished acquiring it, I realized that Adesta is in town more than Amasama. So I've moved to Adesta now, and I think it's good. The mortgage loan is very good. Joy FM and other people are organizing Habitat Fest. Please go there. Go and see the people. They will take you through how to acquire properties. And it is easier because here, there's nothing like a chief who is bringing you any land guy. They will prepare the document, and when you finish paying, the good thing about some of these mortgage loans is that because the repayment period is long, you don't feel it and you don't see it. We think so much about the monies in our hand. Another thing we have to look at, my senior has talked about, is insurance. We must also try to acquire those insurance. It helps a lot. You can, if you don't like life insurance, you can go for endowment insurance. Endowment insurance is insurance where you take it for some years, maybe 5 years. After 5 years, you go for your money, and they will pay you some with interest. And the life one is you have to die before you benefit, and it's your beneficiaries who will benefit. You know, we Africans, we always want to enjoy before we die, isn't it? That's why we don't want to write a will. But Queen Elizabeth herself, in her own wisdom, also decided to die before he bequeathed her property. He also didn't give all to the children. Even when he was dying, they were asking her, he refused. Without apology, don't take me there. But that is the truth. And now I'm told Charles is also not well. But maybe William may take over, isn't it? And if you are not careful, a black man will become a king in England, isn't it? Let's hope so. Let's pray that he becomes so. Other than that, you grant visa to all of us to come back. It's also important you do what we call personal accident for yourself. As you are going, you don't know when you get there. At least take a personal accident for yourself. There are some people who buy very beautiful cars and they do third-party insurance on their cars. Do comprehensive to protect yourself. Insurance is selling your risks to somebody to manage for you. So at least you can sleep. And for me, one good thing that is making me happy is this insurance on death. What do they call it? The ILA. Where you go and take insurance policy, you plan your death. You can plan your death and decide the type of funeral you want. And you just pay some money. When you die, nobody will go and borrow money to do your funeral for you. Then, another area is will. Where Senior has already spoken about it. Anybody can write a will when you are more than 18 years. Even in the army, when you are less than 18 years, you can still write a will. And the law permits those in war to even make law with their mouth. You can still make a will without necessarily giving it to a lawyer. Like Senior said, you write what you want to do, then you make somebody sign for you, and somebody will endorse it. But the technicality associated with will is that when you write a will, the people who are witnessing cannot be beneficiaries. So if you appoint somebody to witness the will, that person should not be a beneficiary. But a beneficiary can be appointed as an administrator or as an executor. So if you force somebody to write a will, and because it's fraudulent, you make him witness, that will not be proper. Again, you can change your will at any time. And the lawyers call it ambulatory. That means you can change it, it can be revoked. So, like people will say, when you are writing a will, don't be annoyed. You shouldn't be in a bad mood to write a will. And you shouldn't be too excited to write a will. You don't see the beautiful lady here. You see her, you start giving promises. That if you allow you to do the doables, then after you realize that, after all, you don't need it again, then you want to change the will. No. Before you write the will, consider so many things. Don't look at being smart. Look at being intelligent. Because the intelligence is looking at the consequences of action and inaction. Where some of us come from. I come from a village called Abroduko. And as I'm standing here, some of my relatives are waiting I die so that they can also benefit my will. And I don't know what my wife will do when I die. So the strategy I adopted is that I look after so many of them to school. Many people have finished school and they appreciate it. So one of them recently saw me. He said I should give him some money. I said, I say, wow, I'm scratching, and get you your padama. So they themselves are coming to realization that As for educators, they don't give properties to their nephews again. They give to their children. So as long as you are alive, they will take whatever they want. So let's plan our life and make sure that and when you write a will and you die, the administrators have to go for a probate. The law is saying that immediately you die, your property automatically vests into the administrators. Then if you don't write a will and you die intestate, you have to prepare letters of administration. And when they are preparing the letters of administration, the Pnbc 111 is showing those who qualify to do it. If you have a wife and children, they can do it without the family members. If your parents are alive, they can also do it. If there's a customer successor, they can also do it. But it is the judges, in their wisdom, are making it in such a way that you allow a family member to write a letter, and maybe one family member and one relative, a wife or children. But the law permits the wife and children. Let them also take this opportunity to appeal to our women to please to understand that the fact that the man has made you wedding does not mean that you own all his property. That is not true. That is not the position of law. That the fact that you are Mrs., it means everything that belongs to the man is yours. No. Let's think that some of these men came from some family. In some families, like some of us, when we are not there, the family is not there. So you have to understand that not all of them will come to you. Some will go somewhere. Mr. Dampa, is that not it? Some will go somewhere, so you must understand. I've been telling my children that you go to school. When you go to school, one day you don't even like my building. It's my cars you like, because the boys, they are driving the cars around. You know, women like sitting in the car, and you see them with the girls sitting in there. It's hallelujah, isn't it? It's interesting. The girls are saying that they can, and the girls are not forced to drive early. So it's not me. And another way you can acquire property is through trust. Mr. Senior also said it. In trust, we have two types of trust: express trust and implied trust. The express trust is where you yourself, you appoint somebody. You are appointing somebody, you are the settlor. And the person you are appointing to look after your trust is trustee. And those who will come are called the beneficiaries. So these three things are there. So anytime you do express trust, there are three certainties: the certainty of intention, the certainty of subject matter, and the certainty of object. The certainty of intention is that because you have created a document called trust deed, then you have intention to create an express trust. Then the certainty of object, there should be a property, either money or building, that you are putting aside to be used to cater for some people. In some other world, they have what you call charity and foundations. The essence of this program is to appeal to some of you who have money, especially like Mr. Ofori Dankwa and Co, who has money, to create estates. As for me and Senior, we don't have money. To create estates, create foundation and charities, so that we can use it to give it back to society. We must give back to society. I can assure you, if you give back to society, your relatives will not worry your wife and children. But where they have not seen you having done anything for the society you came from, and especially your wife doesn't come from their hometown, you are there. So you have to find a way to create a form of trust or charity or foundation. At least, if you can't do anything at all, take about 4 or 5 people of your relatives and educate them to the university level. They are the people who will stand and defend your wife and children when you are not there. But while all of them are going there, they will worry your wife. And I've seen more than 2. And I don't want it to come. So I take care of my nephews and my nieces. And I'm sure you always defend me. Then we have the implied trust. The implied trust is a type of trust that comes impliedly. And we have 2 of them. One is resulting trust, and the other one is constructive trust. The resulting trust is a type of trust when somebody will give you a property to look after it for you, but he never intends to donate it to you. But you see, in marriage, women are entitled to something we call advancement. If you marry a woman, he's entitled to chop money and upkeeping from you, the man. You, the man, you are not entitled to an advancement from a woman. So if by chance your money is there, and he goes to take the money and he uses it, it can be treated as an advancement. But if her money is there, you go and take it. He has not told you to, he hasn't asked you to take it. It's not an advancement. That one will be treated as a resulting trust. Because he never intended to give it to you as a gift. So if you were a man, and a woman gives you money to be building a house for you, and probably there's conflict, then you say, because I bought the property in my name, it's for me, it's for both of us. If the woman can prove that it was she who gave the money to you, the man, to buy the property, that type of property becomes a resulting trust. So you men, there are some people, they call them fine boy, isn't it? Then they are with the woman, and I don't know, some of the women do, they like nice men. Those of us who are ugly, don't get it. And when you get that thing and they are doing fine boy, don't think that the property is yours. If the woman can prove that he was the one who gave you the money. So I will advise the woman, if you are doing those fine boy things, when you give the money to the man to go and pay, let them say that although the receipt is in the man's name, it was paid in by you, the woman. And if you go and pay, that is why the bank, when you are going to pay, you are making deposit. They say pay in by whom? It is paying in somebody's name, but another person's pays and gives you name and address. And people have been using ordinary paying in court to prove that they gave some money to their husband for certain development. In Mensa versus Mensa case, you have to prove substantial contribution. And one way of proving substantial contribution is to say that I was paying money to my husband, and these are the paying. You know, man, when the money is in our account, we don't care where the paying is. You know that in Mensa versus Mensa, the same case was repeated in Atamosis versus his wife. And in Atamosis versus his wife, the thing was, the woman was not working. But he was driving Atamosis to the training ground and bringing his home. And when they divorced, Atamosis was saying that the woman was not working. The court said that no, driving you to training ground, bringing home is a substantial contribution. In John Mensa versus wife, he too, they say it was not working. They say no, cooking for you is also another form of what? Substantial contribution. But one funny thing in law, a man cannot divorce a woman because the woman cannot give birth. Because he's a barren. You can't do that. But the woman can stop with the man because you are impotent. that is why, unfortunately, yes. The law is saying that you cannot stop with the woman because he cannot give birth. But the woman can stop with you because you are impotent. Because the essence of marriage is companionship. Once you can do the undoables, it's companionship. That's how women, Europe, in America, they don't consider too much about children. But if a woman, you are in Africa, and you are about 40, 45 years, and you don't have a child, please, I will advise you that you either adopt a relative of yours as a child, and make everybody knows that he's your child. Or you can go to Osu Children's Home and do that. I have an auntie in Dansuma. He has a very big property. And according to my mother, immediately my mother gave birth to me, the auntie came to that this child is hers. So when I grew up, he called me, he adopted some 2 children from Osu Children's. He said, Moba sounds more time. Then he wrote a will and made me the administrator. The 2 kids are fighting over the property. One say he wants, another one says he wants. So I called and told them that your mother stated in their will that it's for the 3 of us. No, they haven't seen the will. So when they read, now they keep coming to me. Initially, they were not respecting me, so they got to know that I'm a lawyer. Anyway, another thing Another document you can also think about is what we call declaration. It has something to do with you are getting sick, you are down, and you cannot talk. You can do power of attorney. It's only when you are of sound mind that you do power of attorney. Maybe let me talk about power of attorney first. Power of attorney is given by somebody to another person, instructing a third party that you are giving authority to somebody to be doing certain things on your behalf until further notice. Some may be within a time frame. It could be that you are traveling to Europe. You want somebody to look at your back, especially when you are director of a company. When you come by, come and take over. But you can't give power of attorney to a sick person who cannot talk to send it to the bank. When you bring it to the bank, normally we may not take it. You have to do what we call declaration. In that case, somebody who is related to the man should go to court and do declaration that Ebusuapain of Osimesi is saying that Osimesi is my relative. He's sick. So I, as Ebusuapain, am appointing his wife to be taking care of him. That is different from power of attorney. You can't do power of attorney to go to send it to the bank to say that because your husband is sick, he cannot talk. What authority is coming? The authority is not coming from a sick person. It will be of signed man. Another thing is when you are changing your name. You are changing your name. When you are changing your name, you can't use affidavit to change your name. You use what they call gazette. You can only use affidavit to change your name when your name, the spelling, maybe Kojo, K-O-J-O. Then you make it K-W-O-D something. In that case, affidavit can come. But where I'm Richard Atta, and now I've been made a chief in my hometown, and now I'm called Kweku Pencil, the something. Or Sabarama Kweku Pencil. Then, in that case, my name have changed. I have to do gazette. I can't use, without apology, when I was in Kumasi, there were people who were holding different ID cards with different names. Those who were doing kuru things. And that is why I am strongly for this Ghana card thing. Because with the Ghana card, everything is there. When we went to London, you can use somebody's national insurance to work. So if you have your Ghana card, your name, and I also want to appeal to people. Those of you, when you are giving names, you give plenty names to your children. It's not necessary. Try as much as possible to give names that are very hot, compatible. You understand? You see, my name Richard Atta is good, isn't it? Yeah. You can also say John Mason. You are going. I remember I attended Christian Methodist, Free Metro. That's why I went to secondary school. And there was this one class which was very troublesome. Then one day he did something, they brought him to assembly. His name was Joseph Mason. He said, look at the name you have. It's very nice. I thought you have a name like Tete. And I know you're a bad boy. But how can you have Robert Mason be a bad boy? But you see, these were old people who think that certain names were associated with bad boys. And you know those days when they give you guy named Ben, you become a bad boy, isn't it? Yes. But that is by the way. So we can also use gazettes to be doing those things. And affidavit. And gifts, my boss has already spoken about it. Because of the time frame, we could not go inside. But what in my concluding, I'll ask you that for every asset that comes to your hand, try to have a document on it. If you go and buy anything from anybody, it is a property. If you are going, take this A4 sheet. When you get there and he doesn't prepare receipt, prepare one yourself. I, Mr. So, I give you money to Mr. So for the purchase of land. Signed by me. You too, who sold the property. Sign. Then you hold it. At least, if you don't have any evidence, that A4 sheet, you can put it into your trunk and lock, isn't it? So that in future, you can use it to do. I'm sure In concluding, I want to appeal to all of you to take this illiteracy thing very serious, because if we can't, we should all try to write our wills before we die, so that when we die, there will be fight at our back. And the last aspect, I'm concluding again. I'm a family man. I'm not saying something to disgrace myself, but my father per se, who took care of me, who gave birth, did not look after me. It is my uncle and my distant relatives who helped my mother to take me to school. So I've also had that intention of helping people. For those of you who have given some money, please, let's help the community we come from. Let's help our relatives. And you ladies, we are begging you, when the relatives are coming, smile to them. Don't flan your face. And on Sunday, you go and pray hallelujah. Thank you.
Thank you. Wow. That was a very insightful one. We can do better again. Thank you so much. Thank you so much, Mr. Richard Arthur Esquire. That was very, very insightful. Ladies and gentlemen, we are still on the program. Let me quickly mention our organizers. So this has been made very possible by the Financial Awareness Foundation, Center for Financial Literacy Education Africa, Chartered Institute of Bankers, and the FA Association, University of Ghana chapter. We also have very strategic partners that include Access Pensions, Pali Global, Pro Material Limited, Prudential Life Insurance, KPMG, Ghana, Deloitte, Crescendo Consult Limited, Ghana Association of Bankers, the Ghana Think Foundation, all our media partners, and then Bliss Ben Deco. Bliss Ben Deco. Thank you very much for partnering us. I think in the course of time, I will invite three of them to tell us a bit about themselves and what they do.
Considers the trust as an entity. So the profit of the trust is required to be taxed. Okay, just as a company will be subjected to tax. However, the distributions from a trust are considered exempt. And the key consideration here is that the trust must be resident for this exemption to apply. So it means that if you become a beneficiary of a non-resident trust, that gain or income you are receiving would have to form part of your assessable income for the year. But if the trust is resident and the distribution is in the hands of the beneficiary, it is considered exempt. So these are things that are very important, and you know that to the extent that you are able to plan your taxes well, it actually goes a long way to help you realize tax savings, minimize your risk of tax exposures, and also help you improve your tax compliance, which ultimately helps reduce any additional costs that you are likely to incur as a result of penalties or interest associated with non-compliance. So the key takeaways here for us when it comes to the tax implications of estates, and I have said it through the examples that I have cited, is to first of all consider the asset in question, the asset that is being transferred, and its status in line with the definition of realization under the Income Tax Act 896, which is Act 2015-896. Realization is defined as whether it is being transferred, sold, or given out completely to another party, okay, in the process of exchange. So at that point, you need to know whether whatever asset is being given out as a gift or being handed down to you as an inheritance actually qualifies as realization under the Act. The second one is to know whether there are tax implications of this transfer of assets that you are receiving, either as a gift or as an inheritance. And I earlier mentioned that Act 592 provided a specific rate, but under the current Act, it is going to form part of your income. So if you are a business, it will be taxed at 25%. If you are a resident individual, it will be taxed through the graduated rates, okay, if it forms part of your employment income. And then if you are a non-resident individual, it will also be taxed at 25%. So you need to understand what the tax implications around this transfer will be. And then you go ahead to look at whether there are tax planning avenues that you can use in the process of transferring this asset to be able to maximize your benefits under the law. And a clear example is the trust, which I cited earlier, and then also the will, which is transferring under a will. These are the key tax considerations, and I will encourage all of us to share the knowledge on these to people who are planning their estates. And just as Mr. Ifa and Mr. Arthur have already said, we don't need to wait till we die. We can actually start planning from now. If we are planning and giving it out in the form of a gift, we need to look at it from that angle. If we are including it in our will for it to be transferred ultimately to the beneficiary after our death, we need to also look at what the implications will be for this recipient when they ultimately assume ownership of the asset. Thank you very much.
So let's show some love to our able MC. Thank you very much for being here. It's a great privilege to launch Estate and Gift Planning Awareness Month, October 2022. I will start by saying a giving life is a great life. So the act of giving is a great way you can touch and impact thousands of people, millions of people, and even billions of people. Estate and gift planning is an essential element of the overall financial planning process. Estate planning is not only for the rich. Without a plan in place, setting your affairs after you go could have a lasting effect on your loved ones. This is why we decided to create estate and gift planning to educate Ghanaians and help them better plan their exit. If you are not convinced about estate and gift planning, I hope from the presentations that was given, you have changed your mind. And if you are still not convinced, let me summarize what our speakers said to you. If you want to choose who will inherit what among your possessions and valuables, then you need an estate planning. Estate planning allows you the ability to name your children's guardian in the event of your premature death. Reducing taxes on what you leave behind is also a common estate planning goal. Estate planning minimizes the chances of family disputes and ugly legal battles. So then, you have no excuse not to plan your estate. The Improving Financial Awareness and Financial Literacy Movement in Ghana, in our quest to create public awareness, have created 2 campaign months. So in April, we do Financial Literacy Month. And in October, we do Estate and Gift Planning Awareness Month. So during April, we had our Financial Literacy Month, where we touched the media, we touched communities, we touched schools. And we are doing the same for October. This is not a one-man show. This is not a group of people who have decided to embark on a journey. It's an all-inclusive effort. We want everyone involved. And so our master plan is that we are touching financial service and product providers. We believe they have a huge network that they can share this essential information with. We are touching the media. We believe the media is the mouthpiece to all the information that's circulating in our communities. So we want to use the media to touch the people. I believe we don't have thousands of people here, but once the media is able to carry this information and spread it across, we will touch the entire country and we will help people better plan their estates and giftings. Whatever your motivation, estate planning puts you in charge of how you want your care, finances, and family matters managed in the event you become incapacitated or die. So I want to challenge and encourage you to take charge. In conclusion, the improving financial awareness and financial literacy movement in Ghana has these goals. One, we want to significantly improve financial awareness and financial literacy across all ages, across all income levels. So if you have 1 cedi in your account today, we want you to grow that 1 cedi to a point where you will be able to build wealth. If you have 100 billion in your account today, we want you to sustain that amount and use it to touch other people's life. So we are touching every woman, man, and child at least twice a year with education and motivational reminders to get and keep their financial house in order with the current financial, retirement, estate, and gift plans. So today is our official launch for October 2022. And from here, we have 3 other press conferences. In Kumasi, on the 18th of October, we will be in Sunyani on the 19th. We will be in Takoradi on the 21st to create public awareness on estate and gift planning. We also have community outreaches. So we are using our social media platforms to educate and create awareness. So we have daily estate and gift planning quotes. So every day we share quotes on estate and gift planning. We share articles. We share publications that will help people better plan their estate and giftings. We also do a community outreach. So last April we went to Medina Market, but this year we are going to Takoradi Market Center to engage the market women and men on estate and gift planning. We have school outreaches. The FA Association at the University of Ghana Business School will do the Building Blocks to Successful Estate and Gift Planning Conference on October 12. We have a program for the Ghana Association of University Administrators at the University of Ghana Business School. We have a conference at Central University College on October 27th. Koforidua Technical University, October 25th. Kadri University, Sunyani, on October 19th. Aside that, we are doing media campaigns. So we have about 13 media houses here today. So we want you to invite us, invite our ambassadors to come and share on estate and gift planning. When the speakers were giving their presentation, I realized there are a lot of things people need to hear. And so we want you to invite us so that we can bring these resource persons to come and share on estate and gift planning. I will end my presentation by encouraging all of us to get involved in this campaign. Let's share every financial literacy information that we have. Let's talk to our family. Let's talk to our colleagues. In our churches, let's be advocates. In our offices, in our schools. And I believe once we do that, we will help create a peaceful, healthy, and sustainable economy for Ghana. I always used to say that Ghana, we are not where we want to be because most of us are financially illiterate. Even our politicians, most of them are financially illiterate. So if we create this awareness and help people to understand money, know how to use money, know how to sustain it, and also add creativity and collaboration to it, which is also a form of literacy, we will help eradicate poverty from Ghana, and we will have a peaceful environment. Someone will pick a gun to come chase you for your money because you don't have that money. But once we create a sustainable economy, once we create an economy where everyone is comfortable, I think all these social vices will end. So let's be ambassadors for the improving financial awareness and financial literacy movement. Thank you very much.